Please be seated.
Good morning and welcome to the First District Court of Appeals. We have two cases scheduled to be argued this morning. The first case on the docket is C-240671, Hill versus Heichel. My understanding is that counsel for appellee is here, is that correct?
Yes, Your Honor. James Ziegler.
And is Mr. Hill here?
I have not seen him, Your Honor.
All right, thank you. And then the second case is C-240512, State of Ohio versus Donnell Geralds. Is counsel available this morning?
Yes, Elizabeth Conklin on behalf of the appellant. Ready? Candace Stern, on behalf of the City of Ohio.
All right, and it's my understanding that we will be reordering these two cases this morning and that Gerald's will be argued first. Is that your understanding as well?
Yes.
All right. Thank you for your flexibility in that regard. Counsel for appellant, are you ready to proceed?
I am.
You may come forward. Would you like to reserve time for rebuttal?
Yes, 5 minutes, please.
All right.
Your Honors, Elizabeth Conklin on behalf of the appellant, Donnell Geralds. Mr. Geralds was indicted on March 10th of 2023 on 6 counts of possession and trafficking in cocaine and 1 count of weapon under disability. On March 19th, he was released pre-trial on a bond which included electronic monitoring. On August 30th of 2023, the EMU officers appeared at his home and by their own testimony for a routine visit. As they're standing on his porch, one of them testified that they could smell marijuana from inside the house. And when they knocked on the door, Mr. Geralds, in his testimony, took an unusually long time to answer the door, but no time was ever really identified. So when Mr. Geralds answers the door, they just go in. There's no testimony, no evidence that he invited them in, that he said they could come in, they just went in. One of the EMU officers took Mr. Geralds and had him sit down and sat next to him in the living room. The other EMU officer went upstairs and started searching. Not for anything in particular, but just searching. And the first thing they found, other than some marijuana on the bedside table, was a Derringer at the back of a sock drawer in the dresser beside the in the bedroom that was shared by Mr. Geralds and his wife, Janitha.
And counsel, wasn't there testimony that the socks in that drawer were socks that a man would wear, long, dark socks?
Well, I mean, I think that's conclusory. I mean, I wear long, dark socks. And my husband doesn't wear long, dark socks. So I think, just making that conclusion based on the visual of socks without any other evidence to substantiate that conclusion is speculative. And in fact, Ms. Geralds testified that that was her drawer and that those were her socks.
And didn't Mr. Geralds later acknowledge awareness of the gun being in that drawer? And didn't he say that it was there for protection?
He acknowledged when he was shown the gun by the EMU officer, he's like, that's my wife's, and she has it for protection. He did not know at the time where they had found it. There was no evidence that he said, oh, you found that in her sock drawer. There was no indication at all that he had any awareness that that gun was where they found it. And this is relevant because the court found him not guilty of possession of one of the guns that the EMU officers ultimately found that was in 2 bags at the back of a closet in a spare bedroom that he also had access to. So the fact that it was in a sock drawer that belonged to his wife doesn't necessarily mean that he had knowledge of its location. And the fact that the court found him not guilty of another gun, also found in the home, substantiates that claim or that position. And then the other gun, well, so once they find that gun, they reach out to districts for backup, and ultimately I think the 4th district shows up, and they search the rest of the house, and this is where they found the EN57 FN-57 in the spare bedroom, and they found a Glock in a locked gun case in a drawer of a cabinet in the dining room. And the court finds him guilty of the Derringer and the Glock, but not guilty of the FN-57. Our position is that there was, in our manifest weight and insufficient evidence arguments, that there was no sufficient evidence that he had knowledge of and access to those guns. One, the gun was in a locked gun case. She testified that she had purchased all of those guns at swap meets, that the Glock had originally been in her car in its locked case, and that she had, unbeknownst to her husband, she did not tell him, that she had brought it in because she needed to take the car somewhere, and she had brought it into the house and put it in the drawer in the dining room without notifying him of its existence. Our other argument, our first argument is the ineffective assistance of counsel for failing to file a motion to suppress. It's our position that requiring a pretrial defendant who has not yet been found guilty of any offense to waive his Fourth Amendment rights to searches that are based on probable cause and that are pursuant to a warrant is not reasonable in exchange for being released on bond.
Do we know that he actually did that? Are the bond conditions in this record?
They are not in this record, and I'm presuming, because that's the only argument that you could possibly use to justify this search. There is no probable cause. They're standing on his porch. They smell marijuana at best. At the time that this occurred on August 30th of 2023, this is a misdemeanor. You don't get to just go into someone's house without a warrant on the suspicion that the person has committed a misdemeanor offense.
However, without having any documents submitted, do we even know what were the conditions that the court would have placed as part of that pretrial release?
Well, let's assume worst case scenario, that he, similar to a...
Because I'm not sure if your argument is premised on that there's a preset, terms of pretrial, and that those preset terms are violative, or whether it's any court-imposed specific terms, whether those are violative, because we don't have the documents.
Well, I suppose we could look to the transcripts of the hearings, and there's no indication that it was the court who imposed that restriction.
Well, do we have those transcripts? I mean, wouldn't the relevant hearing be the bond hearing in the other case?
Yes.
And do we have that transcript in this record?
I do not know if that's in the record, because it was from, as I called it, a companion case, because that's the case that led to the charges in this case. But
it seems to me as if one of three things are possible. It's possible that there was some piece of paper that he signed that set a standard condition for everyone. Mm-hmm. That's possibility number one. It's also possible that the judge, in setting his bond conditions, gave him some specific condition. That's possibility number two. And it's possible that no condition was set and this was just a warrantless search and the police just went into his house. How do we know which situation we're addressing?
I think that's why I argued kind of all of them, that if you presume that there was some type of order or a list created by the probation department, the EMU office, that says you agree by being released pre-trial to submit to warrantless searches just because we think you might be violating the terms of your pre-trial release, that would be a violation of his Fourth Amendment rights. If the court set specific terms on the record saying you are subject to warrantless searches regardless of the basis for the search, as long as it's a reasonable suspicion you violated the terms of your pretrial release or you're in the process of committing some generalized crime, whether it's a misdemeanor or a felony, it's still a violation of his Fourth Amendment rights. It's still an unconstitutional condition that was placed on him as a prerequisite to being released pretrial.
So to that point, if it were that there was a warrantless search that was not based on anything of any relation to any terms of the pretrial release, right?
Okay.
Then obviously this would be the case to argue it as filed, right? Right, because it would be the basis of the violation and so on. If you're challenging the constitutionality of the conditions that were placed on the pretrial release, help me with this. How is it that it would be properly before us and should not have been raised with that initial case on direct appeal?
He was found not guilty
Okay.
in the original case.
Well, he was ultimately found, I got it, okay.
The case where he was violated,
That's
he
right.
went to trial, was found not guilty, and the day after the not guilty, they indicted him on the unlawful possession of a weapon in this case. So, I mean, the understanding is had he been found guilty on the original case that he was indicted for back in March,
Right.
they wouldn't have even pursued this. But he was found not guilty of all 7 counts. So there was no opportunity to appeal it.
Thank you.
Thank you.
May it please the court, counsel. I just want to address a couple of issues that were brought up before I get to my own argument here. So the Derringer was found in his sock drawer, in a dresser that had his probation officer's card affixed to it. And when he was questioned about the weapon, he responded that the gun was there for protection in case of a home invasion, which goes to the access element. So he had knowledge of the gun and he had access to it because it was in his sock drawer. In regards to the terms and conditions of probation not being on this record, that is because it was not challenged. And it was provided in discovery, as we wrote in our brief, that the terms and conditions of electronic monitoring were provided to
Counsel,
opposing counsel.
can you flesh that out for me? So it was provided in discovery, and that's reflected in the disclosure list of documents that were turned over?
Yes.
All right, thank you.
And because of that, the terms and conditions were not challenged at trial, so that wasn't relevant to his finding of guilt. And that's why it wasn't in our record here for this case. So when Gerald signed the terms and conditions of electronic monitoring and he posted bond, he was consenting to warrantless searches. Gerald's claims that he was induced.
How do we know that? How do we know that?
In
As
terms of
opposed
our-
to presume it, or infer it.
Right. That is the inference here, Your Honor. You are correct.
Isn't it likely as to the options that Judge Kinsley offered that it was option number 1? It was just a set of pretrial conditions that is signed by all defendants as a matter of course?
That is true. Yes. That is one of the options. It's also an option that it was specifically addressed for Mr. Gerald's in his case. But to prevail on his claim
Well,
for ineffective.
can we pause there? I guess fleshing this out even further, there is a potential option number 4, which I didn't exactly think of, that the form that is standard for all defendants could have like a checklist, and that it would be up to the trial court to determine which conditions applied.
Right.
And so that could create yet another circumstance that we don't exactly know from this record which choice it is. Would you agree with that?
I do agree. And when writing the brief, I was challenged with the idea of whether or not to request if the court wanted the terms and conditions of electronic monitoring. So would that be something that the court in the future would like?
But the thing was it submitted into evidence? Because we can't consider something that wasn't
Right.
submitted into evidence by the trial court.
Right. And you are correct that it was not submitted into
Okay.
evidence. But it does exist. It was referred to.
But I
We are-
appreciate where you're going with this.
Right.
But doesn't that kind of go exactly to the ineffective assistance of counsel? The idea that it should have been raised in a motion to suppress, then it would have been part of that whole proceeding.
Well, in the sense that it is relevant to his rights, I would say that it should have been addressed and/or assessed by his trial counsel, and it was. It was provided in discovery. So the terms and conditions of electronic monitoring were provided to his attorney, and his attorney had the discretion to review it and decide whether or not it was a futile act to file a motion to suppress. The state's argument is that it would have been a futile act to file the motion to suppress due to the terms and conditions of electronic monitoring.
And this is something that you brought out in your brief, I believe, on the ineffective assistance of counsel.
Right.
The fact that trial counsel had these documents and had the opportunity to assess whether the path forward would be a motion to suppress.
That is correct, Your Honor.
Well, I think the argument that defense counsel is making is a bit different in that, I mean, we're flying a bit blind here because we don't know. I mean, we might technically know it, but we don't know it from this record, what those conditions say. But I think defense counsel is raising the point that if in fact they do say that pretrial release is conditioned upon consent to a warrantless search, that that's an unconstitutional condition. And that is an issue that defense counsel should have raised, because requiring someone to waive their Fourth Amendment rights in order to secure pretrial release is in and of itself a constitutional violation. I think that's the argument. How would you respond to that?
So in my analysis of Scott, it was on the basis of an own recognizance bond, and that is not what we have here in this case. And part of their analysis was based on the fact that it was an own recognizance bond, and because of that, the rights were not, that person had more rights than a person who was, I guess, a post-conviction release. And they focused on how Scott would be not a huge threat because he did not have any prison history, because he had not been convicted of an offense as of yet. And so I would say that Gerald's is in a completely different situation than Scott. And even in Scott, they say that he had a reduced expectation of privacy. So in paragraph 28, because he signed a form that on its face explicitly waived the warrant requirement and implicitly, through the use of the word random, waived the probable cause requirement for drug testing. But Scott, far from being a post-conviction conditional releasee, was out on his own recognizance before trial, and his privacy and liberty interests were far greater than a probationer's.
But wouldn't you agree that Gerald's privacy expectation is far greater than somebody in a post-conviction posture?
I would agree that it would be greater, but I would not say far greater. I think their focus was on the own recognizance aspect of it. Gerald's was on electronic monitoring. And for Scott, this was someone who was going to be released. And so conditioning his release on him signing a form has a higher constitutional muster, saying, we don't think that you are a danger. We don't think that you will skip you going to your hearings. So we're going to release you, but we're going to force you to sign this form, is different than an assessment of Gerald's, which included, we need a bond. We need to have electronic monitoring. You need to have terms and conditions of electronic monitoring. It was a more tailored situation.
So those are all pretrial restrictions that are restrictions on liberty that are less than being in jail. But how does that include the state's ability to enter into somebody's home without a warrant? Doesn't the home give you that expectation of privacy separate and apart because it's a constitutional right?
I would agree that that is a constitutional right, but I would argue that it was waived consensually for the benefit of being released. So the liberty of being released was worth the balance, or worth that lowered, I guess, constitutional availability of that right, of your home.
But these weren't charges that were subject to no bond detention, right?
That's true, yes, Your Honor.
So Under all circumstances, Mr. Gerald had an affirmative right to be released pretrial.
Yes.
So then why would he be required to waive his right to privacy in his home in order to secure the right to release that he already had?
I mean, that is a good question in terms of why would he be required to? I mean, I would say that there are the compelling governmental interests in having the community be free from further crime. I mean, I would say that drug possession, trafficking charges are usually ones that they keep the drugs in the home. So I would say that would provide evidence or reasoning why intrusion into the home would be a more acceptable situation.
It seems to me there's so many layers to this case. Remind me what it was that the underlying charge was?
So there were
That was
multiple,
ultimately
I would say at
dismissed.
least 8 high-level felony drug trafficking charges
Okay.
and having weapons under disability.
So, again, we don't have the documents, but there's also a potential inference that in there he was not to engage in any drugs, right?
Yes.
And what's interesting is this all begins with that these pretrial officers show up. There's a heavy scent of marijuana. I don't know if there's testimony whether it's burnt or unburnt. There's a prolonged delay before Mr. Gerald shows up at the front door. So there could be an inference that he was to stay away from drugs and that there was probable, there was a probable cause to do a warrantless search for drugs within the home. And I know that there was marijuana found on top of furniture, but depending on, again, none of this was vetted out, right?
Right, it was not.
Whether they felt that really was indicative of what they smelled, because maybe they smelled burnt marijuana that was unburnt, or vice versa, or whatever it was, and you get where I'm going.
I
So,
do.
you wind up in a way of like, okay, that becomes the basis of the search and making it constitutional, regardless of whether what was in the documents with regard to warrantless searches generally. There's so many layers to this case.
And that was...
And the lack of the documents makes it,
Yes. A very large difficulty with writing the
Yeah.
brief is to make sure to keep things out of it that were not part of the record. And also, I just want to go back to the constructive possession argument for a minute in regards to Mrs. Gerald's. So she was caught on a jail call asking Gerald's if the bodies, or if there were guns, if there were bodies on the guns. So it is unconvincing that during her testimony, she said that she purchased the weapons alone and that he was not involved in it.
however, we don't know which one of the firearms that conversation was with regard to.
That's true.
And there were 3, one of them was dismissed at the
Right.
trial court. Can you address sufficiency with regard to that which was found in the dining room furniture drawer?
Right. So constructive possession can be achieved by like access and control. So in the dining room, that is obviously an area where he would have access, and that is the basis for that argument.
What's interesting is that the only testimony, the only evidence we have with regard to that is wife's testimony, and it was placed there that morning. She testifies that she did not let Mr. Gerald's know that it was there, that it was a last-minute decision because of what she had in her agenda for the day, basically.
Right.
So can you address then constructive possession within the confines of the testimony that was offered by wife?
Yes. And it's the trial court's discretion to determine whether or not she was credible as a witness, or what her testimony was accurate. And obviously, the trial court did not find her testimony credible.
Thank you.
Thank you.
Counsel, this was a single weapons under disability count, right?
Yes.
And so both of the guns were charged for just that one count.
Yes, Your Honor.
So even if there's a problem with the evidence as to one gun, would the other gun be sufficient to justify the conviction?
That is accurate, Your Honor.
All right.
So in the state's brief, I reference Sixth Circuit Norris versus Premier Integrity Solutions, that participation in a pretrial release program lowers the expectation of privacy, and signed consent diminished the expectation of privacy. The state also referenced probation cases. Well, United States versus Knights, where the Supreme Court held that status as a probationer and the search condition that he was unambiguously informed of lowered his expectation of privacy. So the court has that avenue if it wants to analyze the cases under a probationary lens, like using the terms and conditions of probation to compare to the terms of electronic monitoring and their analysis. But in regards to,
Does the pretrial release, the statute that authorized pretrial release, does it allow specifically restrictions on a person's home?
I did not see any mention of restrictions on a person's home in that statute, Your Honor.
And that's different than the one for probationers.
That is accurate. So in regards to So I think just in total, Mr. Gerald's was provided trial counsel that was not deficient. And at this point, the Ohio law has not necessarily addressed an issue like this. This is a new area that it would be strange to say that an attorney failed to objectively represent the client properly with an issue that hasn't been vetted necessarily by Ohio courts yet. But unless there are any further questions, I will see the remainder of my time.
Thank you.
Your Honor, the appellant waives his rebuttal.
Thank you. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely written decision. Thank you also for your flexibility in scheduling. We appreciate it. The second case on the docket this morning is C-240671, Hill versus Heichel. The parties may come forward. Good morning.
Good morning, Your Honor.
Mr. Hill, you may come forward.
I've never done this before, so.
That's all right. We'll help you through it.
Okay.
You have 15 minutes in total to argue. You will get to go first and last, and you can split up your 15 minutes any way that you like, but you can speak for a total of 15 minutes. How would you like to divide those 15 minutes?
I just use it all when I'm done with my notes. I'm just done.
All right. You may start whenever you're ready. There are a series of lights in front of you. Do you see those?
Yes.
The green one should be on right now.
Okay.
When you have 1 minute left, the yellow one will turn on, and then when you are to stop talking, the red one will turn on.
Okay.
All right. You can start when you're ready.
So my name is Demetrius Hill, and I just wanted to talk about the case a little bit to give a little backdrop on what happened. So I got hired as a subcontractor to work on a building downtown, and my job was to rehab 2 bathrooms. I've been in construction the majority of my life, so a buddy of mine who got the contract subbed it out to me. So I've been working with this guy for a very, very long time. And so we started somewhere in April. We started on it like for 3 or 4 days. And because there were so many contractors there was 20, 30 different contractors, we was all stepping on each other. So my buddy was like, let's go do another project, we'll come back to this project. So a couple weeks that went by. Now, I always carry a book bag with me. When I have my laptop with me, my book bag goes everywhere with me, but when I don't have it with me, I typically will just leave my book bag just about anywhere because there's nothing in there to steal. So I left my book bag there under the context that we were coming back to do the project, but we never ended up going back. So on May 17th of 2022 is where Hinkle files, Christopher Hinkle is the individual. He files a criminal complaint saying that I broke into his place and I stole a $4,000 watch. And so I don't even know that he didn't say this. I don't even know that I have a warrant. I'm going back and forth in between jobs. I go to child support court on June 6th, and I end up getting arrested. And I'm like,
So were you arrested on June 6th?
June 6th of 2022, I was arrested. And so they took me over to the JC. I got arraigned that morning, June 7th of 2022. I sat there until June 9th once I was able to get bond and be released. June 14th, the grand jury ignored the charge. I just thought it was ignored because I knew I didn't do it, so I just thought it was just ignored. So come to find out that the reason that the charges were dropped was because Mr. Hinkle called the prosecutor and told the prosecutor, hey, I found my watch, Demetrius didn't steal it. I knew I didn't steal your watch anyway, but neither here nor there.
And when did you find that out?
I found that out on June 14th of 2022. And so,
So how did you find that out precisely?
what, that it was ignored?
So you found out it was ignored because it just came out that it was ignored.
Correct.
How did you find out that Mr. Heichel called and said the words that you said?
I found them out from his lawyer, is how I discovered that fact.
During the course of this case?
During the course of this case, I never even knew those facts until he told me about it, and I said, wow. It bothered me the whole time.
And you were deposed in this case?
Yes, well, I sued them.
Right.
'Cause-
But they deposed you?
Yes,
Did you depose anyone?
no,
And when you responded to their motion for summary judgment, did you file your own affidavit or anything other than the deposition that was already in the record?
no.
All right.
So then we get to the case. So originally the case was in front of Judge Melvin Marsh. Judge Melvin Marsh was going to have knee surgery. So she said, Demetrius, I can either A, roll this case to another judge, or B, Judge Ruman is going to step in for me. She said, whatever decisions he makes, I'm not reversing his decisions when I come back. I said, fine. Now, the issue here I was fine with Judge Ruman starting off to hear the case. I was fine with that. But because Judge Ruman made such strong decision on a motion to dismiss, the Ohio Supreme Court made him keep the case. Now, why that becomes dangerous at that point? Because me and Ruman have a relationship that goes back almost to 2007.
Did you file an affidavit of bias and prejudice to try to remove Judge Ruhlman from the case?
No, I didn't.
Okay.
Because I don't know nothing. I'm not a lawyer, so I don't know nothing
Okay.
about none of that stuff.
So Judge Marsh came back after she had whatever she had going on, but Judge Ruhlman kept the case going forward?
He kept the case going forward because of his decision on the motion to dismiss. Somehow the Ohio Supreme Court found out and they made him keep the case.
Okay.
But what I heard you say is that you really didn't have an issue with him having the case per se.
Correct.
So it wasn't like you were like, oh, this judge has a conflict. This judge is gonna, this judge should never take this case. That isn't really where you're coming from.
No.
It sounds like it's really rooted in the statements that were made, and then you're basically saying, and I want to make sure I understand, because I wasn't quite clear, honestly, okay? Whether you were saying that he was disqualified from the beginning or should have, or whether you were saying like he exhibited bias and that undermined the integrity and the fairness of the proceedings.
That's
Or whether you were saying both.
No, I'm just saying that comment that he made at that hearing, that became bias at that point. That I knew at that point this case was not going to have any fairness at all after that comment.
Mr. Hill, so I appreciate that you filed the case yourself, and I appreciate this happened in front of Judge Ruhlman. At that moment, did you ever think about, well, I should get an attorney because maybe this is a little bit beyond me and maybe there's something an attorney could do about that judge?
Well, I'm not rich, so I don't have the ability in these types of cases. From the lawyers that I called, the standard just to start was 10 grand and goes up hourly in that. And by the way, I'm fighting State Farm. I'm not, Hinkle's the person, but State Farm is footing the bill for Hinkle. So State Farm is a $1 billion company. They could sit here and fight me all day on this. So I just didn't have the ability to hire a lawyer.
All right, well,
I would have loved to have done that, but I didn't have that ability.
well, for what it's worth, I think you did a fairly good job below, and you did a good job with your appellate brief, but there are a lot of things here that are because you don't have the knowledge that a lawyer would have had that could have potentially saved your case. Go ahead.
So now I want to move to, so on the motion to strike. So on the motion, I filed a motion to strike the deposition. So I was locked up on something totally unrelated, something totally separate from this. I was locked up in the Hamilton County Justice Center. And Mr. Hinkle's lawyer sent, I guess, notices to the jail. I never got. So I ended up having to go over to the courthouse to do a deposition. I don't know I hadn't had time to study the rules on what I can do, what I can't do in a deposition, what I have to answer, what I don't have to answer. I didn't have time to do any research or anything because I never got the notices. And from my understanding, under Ohio Civil Rule 30, I'm supposed to get all notices. All parties are supposed to. Because Mr. Hinkle has a lawyer, he would have been able to come into the JC and hand me my notice. He didn't do that. He mailed it. I never got it. I even subpoenaed 2 deputies to testify that I never got these documents. Judge Ruhlman didn't even allow the officers to speak. So he could have told them I never received the notices, which I asked him. So in that same deposition, that I asked for it to be stricken from the record, Judge Ruhlman used that very document as evidence to make his ruling on summary judgment. If it had been stricken, he wouldn't have been able to read it. On the false arrest and malicious prosecution. So out of the 3 claims, I had 6 or 7 claims. Now when Judge Marsh was there, she said that she was going to throw out all the federal claims and keep the false arrest, malicious prosecution, and the intentional infliction of emotional distress. Judge Ruhlman threw the false arrest out, saying that I missed the 1-year period. Okay?
Do you recognize now that there's a difference between false arrest and false imprisonment in terms of the statute of limitations?
Yes.
Okay, so do you concede that it was appropriate to dismiss the false arrest claim?
No, I don't. And let me tell you why I don't think so. So when my time starts to accrue, so when I read the false arrest, it said, it's a couple different things that I read of timing. So June 6th is the day that I'm arrested. June 7th is the day that I'm arraigned. June 9th is the day that I got out of jail. Okay, so one of the arguments that I would make is the discovery rule. So the Weedman case and Hildebrand case, I used that case as an argument in Judge Ruhlman's courtroom. I used the Weedman case, and at the time that I originally argued this, at the beginning of the case, the Weedman case had not been, the Supreme Court hadn't made its decision yet. When I re-argued it, the Supreme Court had made their decision on when someone discovers their injury. I didn't discover I was injured until I was released from jail. I didn't discover I was injured when I was arrested. I discovered it once I was released from jail. That's the day I filed it, on the date that I was released from jail. So, and that was June 9th of 2023 is when I filed the lawsuit. So, and then there's,
But in the Wiedemann case, the person who was the victim didn't even know about the alleged defamation in that case until years after the alleged defamation. You knew you were arrested on the exact day that you were arrested.
correct.
And you thought it was false at that moment, right?
No, I thought it was false once I got released from jail because I could have sat there until June 14th. Would my date still be June 6th, the day that I was arrested, or would it have been June 14th where the grand jury ignored the case? But I could have sat there for months. Let's say I had sat there for months. When would my time start?
Can I ask you, you found out, I'm assuming through discovery or something, in the context of this case, that that the watch was in fact found. Do you know when it was that the watch was in fact found?
Great question. No.
Okay.
And
Do you know when it was reported to the state that the watch was found?
no.
Okay. So that's kind of interesting because it seems like what you're arguing is at the time of the arrest, there was a sort of a bona fide good faith, whatever, but at some point there wasn't, and yet you remained you've remained imprisoned and so on and so forth.
Correct.
Okay.
And that was one of my issues with the summary judgment being granted on the issue with the summary judgment being granted to Mr. Hinkle's team was that's a question for the jury. That's Judge Ruman can't make that decision because we have to speak to his intent. Was it malice? When did he find the watch? Where did he find the watch at?
So in his motion for summary judgment, Hinkle says his intent was simply to report what he perceived to be a crime of breaking and entering, and he did not intend to injure you in any particular way. When he did that, did you file any evidence contra that other than your belief?
So I took his text messages that he had sent, and in those text messages that was turned over to me through my interrogatories, in the text messages he says, hey, this guy Demetrius, so the text messages that he's sending to the housekeeper and that he sent to Sean Galloway, the general contractor, he says in there, Demetrius Hill, a convicted felon, his record's long, I know he stole my watch, I just want my watch back. So it speaks to what his intent was then. It wasn't simply just reporting a crime. See, the way they tried to disguise it is that Hinkle's just a worker and works for this company. No, Hinkle owns these companies with a partner. It does speak to his intent, and he even took it one step further and said, I had been staying there 6 weeks. I wasn't staying in this man's apartment for no 6 weeks. I wasn't staying in this man's apartment at all. And then he took it one step further. He says, I discovered my book bag. He found my book bag upstairs in his unit. This guy took pictures of hair on the floor and everything else. Why wouldn't you take a picture of my book bag? Why wouldn't you take a picture where you found my book bag? It'd have been one thing if he had said, I found this watch in Demetrius Hill's book bag. It would have been another thing if he had a picture with the watch in my book bag. That would be a whole different story.
Do you know if the police came and took the book bag?
I called the police department to see if they had my book bag, and the police department said they don't have it.
You never got your book bag back?
Never got my book bag back.
And I'm curious, what was the evidence that the unit was broken into? Because that was part of the factual scenario that led to the arrest, that you had broken in and that you had taken this watch.
Correct. So,
And in your discovery in this case, what was vetted out as to the evidence of the breaking in?
I guess the evidence was simply my book bag. He said he found my book bag upstairs in his unit. He took the book bag to the police department and showed them my journal with my name in it, and I just got charged. That was the evidence. That was it. And the issue here is he said that I picked the lock. I can't pick a lock to something I have the code to. How could I pick a lock when you gave me the code of how to get in and out of the building? So where would I have picked the lock? Now, if all the locks have a different number, I'm assuming, assigned to them. So how was I able to get into your unit? I only got the code to the door downstairs. There was never no need for me to ever go upstairs.
Mr. Hill, you're out of time. You can take a few seconds to wrap up if you'd like.
Okay. I think I've said all that I needed to say here. Thank you.
Thank you.
Good morning, Your Honor. James Englert for Appellee Christopher Heichel and the named corporate Appellees. There's a lot of things to address. I think I'll start with the most recent thing, which is the intentional infliction of emotional distress claim. That's what we were just talking about. That was the only claim that remained after the motion to dismiss. There were 7 counts. There were 2 state law counts, one for false arrest, one for intentional infliction of emotional distress. The remaining 4 were for, all of them were Section 1983 claims. One was called malicious prosecution. One was invasion of personal property. On the motion to dismiss, Judge Ruhlman dismissed everything except the intentional infliction of emotional distress claim. That was not subject to the statute of limitations. That was our defense, so that went on to be heard on the merits. All of the Section 1983 claims were dismissed. The false arrest, which was only made as that was the only state law claim, that was dismissed on the statute of limitations. And there was no count that was originally brought under state law for malicious prosecution. And if I can just switch into that. So the malicious prosecution claim, we think, is that would be a one-year subject also, but it accrues when you discover that, or when you're released from confinement. Now, that just doesn't...
So had that been pled under state law, it would have been a live claim?
Yes, it would have been a claim. And when it was dismissed only on the grounds that all of the federal claims, that Mr. Heichel was not acting under color of state law. And the court never went to never ruled on whether or not the malicious prosecution was subject to a one-year claim or any other claim. It just didn't do that. Had it been brought as a state law claim, then it probably would have. We would have gone into that, but it did not. And I think that Mr. Hill would have had the opportunity after that motion to dismiss to move to amend and to add a state law claim. But as it is, there's no basis for that appeal.
What about the argument that he, in effect, was not arrested under the false arrest claim? He wasn't falsely arrested until Mr. Heichel discovered that he was still in possession of the watch. There are a number of things that aren't in the record because the fact that Mr. Hill didn't take a deposition of Mr. Heichel, and so there are things that are not there. But it's entirely possible that he did not know the reason for his arrest. I don't know what the police told him at the time, but it is really clear under all Ohio law that it's a one-year statute of limitations for false arrest.
Is it meant to be like a bright line rule so everybody knows it's from the date of the arrest, or did you discover any cases that told the statute of limitations for this sort of rationale?
I did not, and Mr. Hill asserted in his reply memorandum that he said, under Ohio law, claim for false arrest accrues on the date of release from confinement, not the date of arrest. See Dunn v. State, 2018, Ohio 2687, 10th District. I looked that up to see, because I am not aware of any other law that's out there. Didn't run across anything. I could not find that case.
What about his creative use of the Wiedemann case for the idea that the discovery, that it's told when the person is unaware?
Well, the court did find a discovery rule in those highly unusual circumstances, but that discovery rule only applies to that intentional infliction of emotional distress claim. That's a very interesting case, the way it went below in the Supreme Court, but there's nothing in that case to suggest that applies to false arrest. And The
Well,
court.
I think I understand
ahead.
him to be claiming something slightly different.
Yes.
That he was not falsely arrested until the moment when Mr. Heichel discovered that he still had the watch. And that perhaps his arrest for purposes of the false arrest came at that moment, whenever it was.
Well, this is not part of the record. We don't know when it is that Mr. Heichel, as soon as he found his watch, he called the prosecutor, okay, just to alert them to that.
I mean,
But
theoretically, it would have been a breaking and entering too, right?
I'm sorry?
It would, like, the way the affidavit is framed, it's not just the watch, it's breaking and entering.
Yes, and by the
That's what the
complaint,
arrest-
you mean by the arresting police officer, yes.
What was the charge listed on the arrest?
I'm sorry, Judge Nestor,
What was
I
the
can't
charge?
remember.
Okay.
I can't remember. He was never actually charged with anything. is
But they
my
must have put
understanding.
something on the arrest warrant of the crime. It's probably.
There is, and I can't recall exactly what it said. But I think, Your Honor, with regard to when it became a false arrest, I think that there is a bright line rule on false arrest. You know when you are arrested, and the court.
But I think Mr. Hill's argument is that it wasn't a false arrest, that it was a proper arrest at that moment, and then later becomes a false arrest. Because when you look at false arrest case law, the premise of the initial arrest was not only improper, but it was, beyond being, it was unreasonable, or it was, and in this case, there wasn't anything to challenge the initial arrest. I think that's his position. I don't know if that's true, that there wasn't anything to challenge the initial arrest, but that, that it then became a false arrest, which I think might be more about a false imprisonment. I don't know.
But certainly, I mean, in so this false arrest claim was decided on the motion to dismiss, and that was with regard to what was here in the complaint. And in the complaint, on May 17th, 2022, the plaintiff was charged with breaking and entering and physically arrested on June 7th. That's paragraph 6. Later in 48, he says, Christopher Heichel had the plaintiff arrested on June 7th, 2022. And that appears in his section 1983 false arrest claim. So that's what we had to go on, and that's what Judge Ruhlman had to go on when he ruled on the basis of the motion to dismiss. We were looking at
We don't know, as
the
I'm
allegations.
recalling Mr. Heichel's affidavit, it is not specific in time to when he made the phone call to the prosecutor to alert them that he had found the watch. Am I recalling that correctly?
There isn't. I don't recall anything in the complaint about that.
I'm speaking to Mr. Heichel's affidavit.
I don't think that he states the date.
As to the affidavit, there was no response with any evidence from Mr. Hill in opposition to the affidavit itself. No facts were put in by Mr. Hill.
That's correct.
He seems to rely on those text messages, and I believe the text messages were a part of the record, though.
They were a part of the record. We filed them, Your Honor.
Okay.
And so they were brought up in the context of, whether there was an intent to injure him under the emotional distress claim. I don't think that, you can take a look at them. I don't think that anything in there indicates an intent to injure Mr. Hill. He did find out who Mr. Hill was because he found his name it was in a journal in the book, in the backpack. And so he looked him up, and then he recognized him from having been on the job. But, this goes to, and we also pointed out
And that
that.
gets me to the question I'm just curious, what does the record have in support of that the unit had been broken into?
There were three separate times when.
The reason I'm raising that is because you just said that he recognized Mr. Hill as being someone who had been on the job.
Yes,
Okay.
yes. And, Your Honor, a kind of underlying point here, we are not trying to prove that Mr. Hill was in that apartment. That is not what is being litigated here.
No,
We're-
but that was part of the underlying basis of how we got here. It wasn't just that the watch was missing, it was also that the unit had been broken into.
That's correct. And so in Mr. Hill's affidavit, and it's Mr. Heichel's affidavit, rather, he says that after the crew left, he was not staying in his apartment, and he was staying elsewhere. But he came back to that apartment where the work had been done. No work was done in his apartment. Okay, that's in the record. It was done in another unit in that building. When he came back to his apartment, there were 3 times in April and May when he came back, and on each time he found footprints with dirt on them that were in the apartment. He found hairs in the bathroom. He found other things indicating that somebody had been there. After each time, he called the housekeeper for the building and had her clean it, and then when he returned a second time, he found the same sort of indicia there that somebody else was there, had it cleaned, returned a third time, and again, and we submitted, he took photos of hairs, we submitted that, and so it was the third time that he found the backpack there. So he knew that somebody had been in his apartment on 3 separate occasions.
But the
When the name
backpack was in
comes
the
up, he
unit
calls
that
the
was being
police.
worked on.
I'm sorry?
The backpack was in the unit that was being worked on, not in his unit. Is
That's
that correct?
correct.
Okay.
No, Your Honor.
No? Okay.
So
Mr.
the
Hill,
backpack, as I understood it, was in the dirty unit.
the backpack, I'm sorry, Your Honor, just to clarify, Mr. Hill's testimony was that he had left the backpack in another unit in that 4-unit building. It was found by my client, Mr. Heichel, in his apartment, the one where he also found evidence that somebody had been in. So he's just reporting what he found when he calls the police. You know, and at that time, he has a name on it, and he calls the police and say, hey, somebody's been in my apartment.
And it looks like this person with the book bag. At
And,
least that's a reasonable inference.
yes,
But, like, there's no police deposition, there's no police affidavit about whatever their interaction was with Mr. Heichel, or whether or not there was some kind of inappropriate, pursuit to get Mr. Hill as opposed to some other suspect. The police nothing from the police perspective is in the record.
nothing is in the record, and I'm not aware of anything to that effect. Our main point of the intentional infliction of emotional distress claim is, we did cite the no intent to injure him. The main thing with that is that this was not extreme and outrageous conduct. There's a lot of cases in Ohio where somebody has been arrested, and then they may or may not have been dismissed at some point afterwards, but responding to an apparent crime by calling the police does not constitute extreme and outrageous conduct that is needed for that tort to exist. Your Honors, I don't know if you have any particular interest or want me to. There were some circumstances on the with regard to the motion to strike the deposition or the motion to stay. Mr. Hill wanted his deposition transcript struck because he didn't have assistance of counsel. He didn't feel that he had due process there, and he says that we didn't serve him. What we did do was, as you're required to do under Rule 30A, I served a notice of deposition at his address, didn't receive a response, did a search, found out that he was confined. So at that time, I did a Rule 30A motion to the court to allow his deposition to take place. So that was before the court, and then Mr. Hill filed a response to that from jail, opposing that motion.
So he was aware that you were attempting to take his deposition?
He was aware of that, Your Honor. And then after that motion was granted, then we sent an amended notice of deposition to the jailhouse, and he was brought over, but he was left in another room. I was sitting in a room for 2 hours, and the deposition never took place. He was returned to the jail. So I re-noticed the deposition for 10 or 14 days later, and that one actually took place. So, and then Mr. Hill came in and he was deposed. So I think that he did have notice that we were intending to take his deposition. It would be reasonable to assume that the party that you have sued wanted to take your deposition. Maybe that's why he was in the court. So that's the way that happened. And this issue of bias on the part of Judge Woolman, I don't think that anything in the record shows that there was any bias whatsoever on his part. There were hearings on this motion to strike deposition. There was a hearing on that. There was a hearing on the motion to dismiss, at which Mr. Hill was able to speak as much as he wanted. There was a hearing on the motion for summary judgment. The only time that Judge Woolman said anything about Mr. Hill was very early on, in the very first time that Judge Woolman was on the bench. He said, "Oh, I think I know you. I think I've sent you to jail. Do you have any objection to my continuing in this?" And he said, "No, I don't, Your Honor." Now, later, because Judge Marsh didn't step in and handle the rest of the case, he thought that was he could have objected to that. He never did in any of the hearings that we had before the court. He never made an objection to Judge Woolman. And if you look at that motion to strike deposition, the only thing that he said was, he was saying that he was before the court asking for it to be struck because he didn't get notice, and the judge asked, "Well, why didn't you get notice?" And he said, "Well, I was in jail." And Judge Woolman says, and this is in the record, says, "Well, that's on your dime." He says, I can't do it. He says that we allowed the deposition to take place. There was a motion. Those were the only words that Mr. Hill has ever raised in these appellate briefs as being an indication of bias.
With regard to bias, I believe that an argument this morning was that Woolman didn't allow the officers to speak, that he wanted the officers to speak with regard to him not receiving the notification. How would you address that? It seemed like he was arguing that was an indication of bias, his determination not to allow
He did bring those two
the
officers there. Judge Woolman asked them some questions. I don't recall, frankly, if Mr. Hill said, "Well, I have other things that I want them to say, and can I bring them to the attention of the court?" I mean, Judge Woolman was extremely liberal with all the parties and hearing every argument in this kind of very convoluted case. So I can't speak any further, but I don't think that, but I mean, I think the reason that he brought them to the court was to say that he did not get actual notice.
Mm-hmm. That's what I
And
understood in the argument. And what I understood was he was saying that was an indication of the bias that Judge Woolman had towards him in the determination to disallow the officers to speak.
Judge Woolman didn't premise his ruling on the fact that he did or did not receive notice in this. So I don't think that, to me, that's not material.
Counsel, you're out of time if you'd like to wrap up.
Thank you, Your Honors.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. Enjoy the rest of your day.